This July, the U.S. Attorney's Office in the Southern District of New York brought another insider trading case that is based on the trading of digital assets. This case, which is brought against the former employee of Coinbase, came just 1 month after the same office brought criminal insider trading charges against the former employee of Opensea. These two cases are the first ever criminal insider trading cases that are based on the trading of digital assets. And in addition, the SEC filed a civil action against the former employee of Coinbase, alleging that the insider trading involved cryptocurrency tokens that were securities. These cases appear to be the beginning of a much larger wave of insider trading cases, and they also suggest that the SEC is likely to start treating a much larger number of digital assets as securities. So cryptocurrency companies and investors are starting to wonder what all of this means. Since I used to work in the U.S. Attorney's Office that brought both of these criminal cases, and I've been representing cryptocurrency companies for nearly a decade, today I'd like to explain exactly what's going on. And I'm going to try to clear up some of the confusion by explaining the nature of the DOJ's insider trading case, the nature of the SEC's insider trading case, and what this means for cryptocurrency companies and people who buy and sell digital assets. Coinbase is one of the largest cryptocurrency exchanges in the world. And Coinbase users can buy and sell various cryptocurrencies through their user accounts at Coinbase. Periodically, Coinbase adds new cryptocurrencies to the list of cryptocurrencies that can be purchased through Coinbase by its users. When Coinbase does that, it's common for the cryptocurrencies to go up in value after it becomes public that the cryptocurrency asset is going to be listed on the Coinbase platform. For that reason, Coinbase keeps the information about what digital assets are going to be added to its list of approved assets that can be bought and sold highly confidential. And it prohibits its employees from sharing that information before it becomes public. The indictment alleges that the former employee of Coinbase used this confidential information to unlawfully enrich himself. That employee worked at Coinbase as a product manager, and he was assigned to the Coinbase asset listing team. So he often knew when a cryptocurrency was about to be added to the list of assets that can be purchased by users on the Coinbase platform. He allegedly tipped off his brother and a friend of his brother about cryptocurrencies that were about to be added to that list. According to the government, these two would then purchase the cryptocurrencies that were about to be added to the list, wait for them to go up in value once they were added to the list and once that became public, and then sell them for a profit. The federal government alleges that this is a crime because these three men fraudulently deprived Coinbase of its exclusive use of the information about what cryptocurrencies were about to be added to the list of assets that could be bought and sold on Coinbase. The same day that the Department of Justice filed its criminal action, the U.S. Securities and Exchange Commission filed a civil case. Interestingly to me, the Department of Justice filed its case in the Southern District of New York, out of the office where I used to work, and the SEC filed its action in Seattle, where I grew up. But the SEC used a very different legal theory than the Department of Justice. The Department of Justice based its criminal charges on wire fraud. That means that it was a fraud that makes use of wires, and wires include things like phone calls and almost any use of the internet, such as email communications. The SEC, on the other hand, alleged that the insider trading violated a securities statute. Now, because the DOJ didn't allege that there was insider trading of a security, the DOJ has no obligation to prove that any of the tokens were securities. The SEC, on the other hand, does have an obligation to prove that the tokens are securities. And to meet this obligation, the SEC has alleged that 9 of the tokens that were purchased by these 3 individuals that are charged with insider trading were securities. The SEC's allegations in its case against the former employee of Coinbase are a potential bombshell for the US cryptocurrency industry. By suggesting that 9 of the cryptocurrencies that are bought and sold on one of the largest regulated US cryptocurrency exchanges are securities, the SEC is implying that it is possible that many, if not most, of the other cryptocurrencies that are being bought and sold also are securities. It's important to keep in mind that the SEC only identified these 9 cryptocurrencies as securities because it was necessary in order for the SEC to file this enforcement action against the former employee of Coinbase. This is what people mean when they accuse the SEC of regulation by enforcement. You have a situation in which even the largest and most sophisticated companies that do business with cryptocurrencies and have sophisticated counsel and sophisticated compliance functions are unable to accurately predict what the SEC's position is going to be with respect to individual cryptocurrencies concerning whether they are securities. And try as they might to predict this, often they don't find out what the SEC's position is until the SEC reveals it by filing an enforcement action in which it alleges that the cryptocurrency is in fact a security. The position that the SEC has taken in its case against this former employee of Coinbase seems to suggest that there may be a large number of cryptocurrencies that are being openly bought and sold in the United States that are securities. And taking this position threatens to destabilize the entire US ecosystem that has developed in the cryptocurrency industry. And that's because if the SEC is correct, or even if it's incorrect, it may be in a position to bring enforcement actions against a large number of companies that do business in the cryptocurrency industry. Companies that issued cryptocurrencies could be charged with making an unregistered securities offering if those cryptocurrencies are securities. Companies that allow US persons to exchange their fiat currency for cryptocurrencies or exchange one cryptocurrency for another cryptocurrency could be charged with unlawfully operating an unregistered securities exchange if those cryptocurrencies are securities. Companies that are engaging in buying and selling of cryptocurrencies for the account of other people, their customers, could be charged with operating as unregistered brokers. Companies that just are involved in marketing or soliciting the purchase of cryptocurrencies could be charged with being unregistered brokers. And even companies that don't even have customers, that are just buying and selling cryptocurrencies for investments under their own accounts, could theoretically be charged with being unregistered dealers if they're buying and selling cryptocurrencies that are securities. So there's a lot of possibility of the SEC bringing enforcement actions against major players in the United States. And obviously this unpredictability and instability is bad for the cryptocurrency industry in the United States. Given that US government agencies have filed both a criminal action and a civil action, a lot of people are asking what will happen next. First of all, the criminal action that was filed by the US Attorney's Office in the Southern District of New York will definitely go forward, and that is because it's governed by the Speedy Trial Act. So there's a clock running and the criminal action has to proceed. The civil action may go forward, but it's more likely that it will be stayed pending resolution of the criminal case. And with regard to both actions, it's really too early at this point to know whether they would be going to trial ultimately or whether there would be some type of resolution before trial. One thing to be very concerned about in the SEC action, however, is that there's a lot of reasons to think that the outcome could be unfairly slanted in favor of the SEC. And there are a few reasons for this. One is that the individuals who would be making the argument that the cryptocurrencies are not securities don't necessarily know very much about those cryptocurrencies. This isn't a case where the SEC is going after the issuer of a cryptocurrency who's very familiar with things like how decentralized it is, who controls it, how revenues are ultimately flow to holders of the cryptocurrency. Instead, the SEC is just going after some former employee and two people that were known by that former Coinbase employee for unlawfully trading the cryptocurrency. None of those people may be that familiar with how the cryptocurrencies operate at all. So that gives the SEC a tremendous advantage in an argument about whether or not the cryptocurrencies are securities. In addition, the individuals that are charged with insider trading don't have a lot of incentive to argue that the cryptocurrencies are not securities. They may make that argument in order to win the case, but ultimately, if they're given an opportunity to settle the case and admit that the cryptocurrencies are securities, they may do that because they don't have any incentive to defend the fact that the cryptocurrencies are not securities. So their incentives are very different than, for example, the issuer of the cryptocurrencies, whose entire business is oriented around those cryptocurrencies and who would have a strong incentive to fight the SEC's allegation that the cryptocurrencies are in fact securities. And finally, the background dynamics of the case are bad. If the SEC had brought a civil case against the issuer of the cryptocurrency, they would be going before the court and saying, look, there's this company, they're operating a cryptocurrency platform, perhaps the users are very happy with it, but we want to stop them from engaging in this business activity. That's a very different dynamic than when the SEC goes in and says, we're going after an employee. That employee illegally and secretly stole a bunch of confidential information, but in order to bring our case against this individual, we have to prove that the cryptocurrency is a security. The dynamics and the way in which the court is likely to perceive the litigants is very different in that case than in a case where the SEC went after the issuer. There are several things that cryptocurrency companies operating within the United States can do now in light of the action that the SEC has taken against the former employee of Coinbase for insider trading. First, they should reevaluate whether cryptocurrencies that they're using in their business potentially are securities. Although the SEC hasn't made clear exactly when it will be treating cryptocurrencies as securities, it has provided a lot of guidance that is helpful. And in addition, in the action that the SEC brought against the former employee of Coinbase, it went through for each of the cryptocurrencies and explained the factors that it used to conclude that those cryptocurrencies were in fact securities. The second thing that companies can do is evaluate how regulations that apply to the use of securities would apply to that company if the cryptocurrencies that they're using in their business are deemed to be securities. And it remains to be seen how a lot of the law is ultimately going to develop in this area, and there's a tremendous amount of ambiguity. But good news, I'm a lawyer. So if you do have questions about how securities law applies to the buying and selling of cryptocurrency in the United States, give me a call. I'd be happy to talk to you.